My name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues. And today we're going to talk about assets, asset preservation, and how not to lose your assets in your divorce. You have to understand, though, that when you say, how do I not lose my assets in the divorce, the operative word in that sentence is my, not assets. How do you not lose your assets? Because you got to remember, things that were accumulated during the marriage aren't only your assets, they're your spouse's assets too. You both own that house that you bought during the marriage. You both own that car that maybe you're driving. You both own those stocks and bonds that maybe are in her name, but the stocks and bonds belong to both of you, even though they're in one name. So when we talk about how do I not lose my assets, it's a loaded question, because those assets are only half yours and half hers. So if you've got, I don't know, a vehicle, and the vehicle's worth $20,000, and you wonder, how do I not lose my car? Well, remember one thing, that car that you're driving, that car is half yours and half his. So when you talk about how do I not lose my assets, are you really talking about the whole asset, or are you talking about your piece? Your piece is going to be yours. You're not going to lose your piece. The court is likely to find an equal division of these assets and make best efforts to do so. So you're going to get your half, and the other party's going to get their half, and the attorneys will make sure that that happens. Now, if by saying, how do I not lose my assets, you're talking about something that you acquired before the marriage, and therefore it truly is yours. It's something that you had before this person was even a twinkle in your eye. You already had that 401k plan going. How do you avoid losing that? Well, the answer is that the lawyers can make sure, and the court will order, that prior acquired assets remain yours. Here's the key, though. The key is, did you do something to compromise the integrity and the ownership of that asset? What do I mean? I mean, did you take that car? Did you take that bank account? Did you take that house that you owned before the marriage and gift it to the marriage? How does one gift a house to the marriage? Well, it's very simple. You take your house that you owned in your own name, you get married, and you decide, oh, here, I'm going to do something nice. I'm putting my new spouse on the title. Well, you know what you've just done? You've taken prior acquired property and made it into a marital asset. In essence, you've gifted it to the marriage. Well, you know what just happened? You just get away 50% of your asset. Because in an impending divorce, they're going to say, well, wait a minute, this is in both names. And you're going to say, well, but I owned it before. Yeah, you did. And you went and you made a very magnanimous gesture. And that gesture is a costly gesture. Now, can you argue that, well, I gave from the marriage forward, but the value before I gave it should be mine? You can argue that. Whether or not you're going to be able to persuade the court that that is fair and equitable under the totality of the circumstances is very much going to depend on what else goes on. But remember one thing, your assets during the marriage, you're going to get to keep your half, the other side's going to keep their half. If you're worried about keeping the stuff that you owned before, you need to make sure not to do something that will challenge the integrity of the title of that asset. If you have questions about that, reach out, and we'll be glad to help you out.